Good afternoon, everyone. Trust everybody's weekend is going well, and thank you for joining YRP's KSS session for the month of February. We have with us our facilitators here in the session, Mr. Obina Ubani. Mr. Obina Ubani, could you please
Hello,
say a
good
few
evening.
words?
Yeah, I'm here. Good
Good
everyone.
afternoon. Yes, thank you. So today's session is titled Unmasking Music Sampling, Rights, Wrongs, and Remedies, presented by Mr. Ubani Obina, a partner at Stetson LLP and Optic Music Limited. A brief about Mr. Ubani. Mr. Ubani is an entertainment lawyer, music executive, and entrepreneur with deep expertise in music rights management, publishing administration, catalog acquisition, and high-value entertainment transactions across Africa. He is the founder and principal of Optic Music Limited, a music rights management company that currently administers over 200 music catalogs, providing publishing, administration, royalty collection, and long-term exploitation services for African songwriters, producers, and rights owners globally. He is also a partner at Stetson LLP, where his practice is focused exclusively on the music business. In this role, Obina advises artists, producers, record labels, and music companies on recording agreements, publishing deals, distribution structures, catalog transactions, and intellectual property strategy. He has been directly involved in structuring and negotiating music industry transactions with an aggregate value exceeding 1 million USD, with a strong emphasis on ownership preservation, rights optimization, and sustainable revenue generation. He is widely recognized for his thought leadership on music publishing, royalties, and rights ownership in emerging markets, and regularly speaking at industry masterclasses, panels, and forums across Nigeria. In 2024, he was named one of Turntable's chart's 30 under 30 power players in the Nigerian music industry. So as you can see from the brief of Mr. Obani, he has that wit and that bandit to be able to deliver a thought-provoking session on our topic of mastering, music sampling, rights, wrongs, and remedies. So, Mr. Abina, I yield the floor over to you.
Thank you very much. So I guess you're going to be helping me with my slides, right?
No problem.
Um,
No problem.
Thank you very much for that. So good day, everyone. So this is not going to be your regular masterclass because we are from the entertainment industry. We do things a different way here, right? So this is going to be, I'll call it a practical laydown on what requires of you when you are trying to deal with music rights and music rights exploitation. So I felt like to start this conversation, I believe that we should lay foundations to it, right? We should understand what we are dealing with. So the question everyone will ask me is, what is music rights? What does that even mean, right? And what are the major divisions of music rights? So I will start by saying that there are two major core music rights division. We have the sound recording on one part, and we have the publishing on another part, right? So I'll try to break this down, and I will always be giving an illustrations just to take it down. So the first thing first is obviously what is sound recording. So sound recording is basically the combination of the lyrics and the melody, right? So to drive home that point, whatever you hear whenever you go online to stream your song on any distribution platform, whether it's Audiomack, Apple, Spotify, what you hear at that point is what we call sound recording, right? You are hearing the audio version of it. So sound recording is basically the combination of the lyrics and the melody. So to make it more easier, I'll possibly say that when you go online to stream a music, what you are basically streaming is the sound recording of that music. Now, which is different from publishing, right? So publishing is the underlying composition. So we're talking about the lyrics and the melody being different, right? So to make this more easier to understand, I will use an illustration. So let's say there's a song called Door. There's a song called Door by Shake, right? Now that particular song will be our point of example. Um, for the sound recording of that song, whatever you hear on Audiomack, Spotify, Boomplay is the sound recording. However, when you talk about publishing, which is the underlying composition, you are talking about who owns the lyrics, who wrote the lyrics, or who produced the melody. In this case, we're talking about the songwriters and the composers. Now, if we're going to keep using Ashake's Door as an example, when you're talking about the composition of that song, you're looking at Ashake as a songwriter. He wrote the song, and then we have Magic Sticks, who is the producer. He produced the song. So these are the two major holders of the right to the publishing. However, as we always know, there are different players for different music rights. When it comes to sound recording, the Copyright Act clearly provides that whoever financed that recording owns the copyright to it. So that basically means that if Ashake is signed to a record label, in this case, Ashake was signed to YBNL and Empire, that's that kind of context. While the sound recording copyright belongs to YBNL and Empire. Now, which is different from publishing, right? Because publishing on its own end, if you want to clear the publishing right to that song, you have to ask yourself who owns the publishing. Like I explained earlier on, there are two major players when it comes to publishing. We have the songwriters, we have the composers. Songwriters are those that wrote the song, the lyrics, right? Composers are those that made the melody. And then we have the publishers. Now, the owners of the publishing is not far-fetched. It basically means that if you're going to clear the song, you have to work with Ashake, right? Olade Ahmed, right? And then you have to also clear with the team that's representing Magistics, who is the producer. So I think with this little foundation, we can move to the next slide. So please can we go to the next slide. Thank you. All right. Now the question becomes, this music rights I just explained now, what is the protection behind it? Are they even recognized by the Copyright Act? And how do you go about that? Now, I want to start by saying that Section 1 of the Copyright Act clearly provides for, recognizes musical works and sound recording as a copyright that is deemed for protection, right? And then the major thing that we need to understand the fact that is, when it comes to copyright, there are two major benefits that you get from it. So if you're an owner of a copyrighted work, or your licensed copyrighted work exclusively, there are certain things that you have which are called benefits. And the two major benefits are the economic benefits you get, right? And then the moral benefits. So the question is, what are these economic benefits? Now, Section 9 of the Copyright Act makes provision for what you have to do as the owner of the copyright work to be able to leverage on it to make economic benefits. Vis-a-vis, you have the exclusive license to use this work, and you have the right license to also transfer your right to this work somebody else to use. That basically means that nobody can use your rights on this work without your consent or without your due consent. Now, the first thing first there is the reproduction. So you have the right to give anyone the license to produce your work on any platform. You have the right to grant someone the access to publicly perform your work. And this basically means having your work on played in maybe let's say a mall, in a club, right? And any public space. Then adaptation, you have the right to also grant audiovisual companies, movie companies, production companies the right to use your work on any audiovisual product, which also goes back to broadcasting and communication to the public. Now, for the economic benefit, that basically means that before anyone has a right to like license your work, right, the person must come through you. The person must have gotten a written approval from you. And this is different from the moral benefits. So the question becomes, what do I mean by moral benefit? Now, moral benefit deals with your reputation, right? Your belief. Now, because you are the owner of this work, because you control the copyright of this work, you have an exclusive license to ensure that whoever is using your work, right, is using it according to what you believe in, or is not against your reputation. Now, if you want to reference this, you can look at Section 14 of the Copyright Act. Section 14 of the Copyright Act recognizes moral rights as a major right that whoever controls any musical work or sound recording can be able to access to. And then Section 41 now makes it very clear that if you infringe on that particular moral right, the owner of that right has every foundation to like lay claims to that and take you to court. Now, I also use an example to drive home this point. because it's very, very important. Now, for moral right, let's say, for example, you are you're a Muslim, right? And you make a song. Then let's say, for example, Nigerian brewery comes to you and say they want to use your song for their commercial, right? They want to use your song for their commercial, and your religion is against alcoholic beverages. So basically, it's now an idea of your belief. You have the right to say, I don't want my song to be used on this commercial because it's against my belief, right? And then at that point, nobody can do that without that consent. So even if, let's say, for example, the economic benefit is okay, you're okay with what they want to use the work for. But if you believe that the use of that work will be against what you hold dear to yourself or your belief, your reputation, right? Another example is possibly a company trying to use your work for an S-rated movie. You have the right to say, I don't want that, right? Now, the thing about this moral right is that when it comes to contracts, there's always a provision that says that you can waive your moral rights, but then this has to be clarified. And an owner of copyrighted work can waive his moral rights, but cannot transfer his moral rights. What that basically means is that you can waive for that particular transaction the right to use to be able to enforce your moral rights, but you cannot transfer that right. So I think it's very, very important that we understand these two benefits that comes with protection under the Copyright Act. So with this explanation, I think we can possibly move to the next slide. Now, so I felt like it was very important that we lay this foundation before we come into sampling, right? Because I believe that these foundations were very important and also clarify what sampling is all about. Because sampling is it's not that technical, but it's very, very important that you understand what it deals with. Now, what's sampling? Can go online and see different definitions, but I'll give you a practical definition. So sampling is using a portion of an existing sound recording in a new song. Now, let me drive home with an explanation. Let's go back to my example. Ashake has a song called Door. You want to use a particular timing. Let's say, for example, you want to use the first 50 seconds of that song, right, on your own song. Or let me say I'm an artist, right, and I want to use 50 seconds of Ashake's Door on my song, right? I cannot do that without clearing with the owners of both the sound recording rights and the owner of the publishing rights. Both right holders must approve before I can use that sample. Now, what that basically means is that I need to clear with YBLNL stroke Empire, who controls the sound recording rights, and then I need to find who are the publishers or who are the people that are controlling Ashake's publishing, and who are the people controlling Magic Stick's publishing, and I need to clear with them too. If I don't clear these two rights, I cannot use that song. So sound recording requires you to clear with not just the owner of the sound recording itself, but the owners of the composition. The problem we have is that most lawyers and even most critics that want to sample a song just believe that because they have access to the owners or the holders of the sound recording rights, they can just go and clear and that's enough. No, that's not enough, right? You still need to find a way to clear with those that control the composition, because sampling is the usage of a portion of the existing sound recording. So because you're using the existing sound recording, you are not using just one composition. You're using both the lyrics and the melody, and both of them must be cleared in addition to the sound recording itself. So let's go to the next slide. Now, I felt like it's very important that we differentiate between sampling and interpolation, because I believe that this is another controversy that's always coming up on social media platforms, which I don't even know why. But the first thing we need to understand is that there's a big difference between sampling and interpolation. Now, interpolation is when you try to record or use the underlying composition of a song. Let's say, for example, you have a song. Let's keep using Do by Ashake, right? Now, Do by Ashake, you want to possibly use just the sound, the melody of that song, right? In that situation, you are not using the full recording. You're just using a bit of the underlying composition. And like I explained earlier on, because there is a big difference between sound recording and publishing, you don't need to go to clear with whoever controls the sound recording if you are just interpreting the song. So in this particular context, you're going to clear with whoever controls Magic Stick's publishing. So in this case, if you're going to just use the sound, the melody itself, you have to reach out to who controls Magic Stick's publishing and try to clear that with them. Now, I think it's very important that everyone take this note of this, because when someone comes to you and say, I want to clear a sample, most times it might basically mean that they want to clear an interpolation, but it's left for you as a lawyer to basically understand what's the difference. Because the client might not know the difference, but you should be able to understand what that difference is. So when someone comes to you and say, I want to clear a sample, first thing you need to ask the person is, can I hear the song? All right? Can I hear the song? Can I hear the sampled version of it? Now you should be able to determine whether this song is, if it's a sample or an interpolation. And with that idea, you would know who you have to reach out to get that song. I think this is the easiest way to like enter this conversation, right? So I think we can move to the next slide. Now the next question is, what happens when I use a sample without consent, right? What will happen to me, right? Now it's very clear that the Nigerian Copyright Act clearly provides that there is provisions that recognize
I
the
mean,
Copyright Act has made
sorry.
provisions.
Yeah, sorry for that. I think the child, I had to remove the child's. I'm sorry about that. Okay.
It's fine. It's fine. So there are certain provisions from the Act that provided for protection of copyright art, a copyrighted work, right? So basically, if you are going to use a work and then you do not make your due diligence done, right? That's to say, you don't clear with the right holders. The Copyright Act has made provisions that contains both civil and criminal liability. So, and both of them can be done concurrently. That's the funny part of it all. Now, Section 36 has provided that if anyone does any of the art I explained earlier, or which is the right to reproduce, the right to publicly perform your work, the right to broadcast your work without your consent, without your knowledge, without your approval, you have every right to that would be deemed a copyright infringement, right? And you have every right under Section 44 to take actions. Now, the actionable court here is the Federal High Court, which has jurisdiction when it comes to corporate matters. And the remedies that are available to you includes you have a right to seek for damages, you have a right to request an injunction to restrain that person from going ahead to use that work. And then there's what we call account of profits. That is to say, if someone has used your work and is already making money from it, if you take the person to court, you have the right to request that whatever money the person has made from this work should be accounted to you. Now, there's a new part. There's a new protection that our new Copyright Act provided for, which I want to make mention about. And I think that's next slide. Let's talk about it. Now, previously, under the last Copyright Act, there was nothing like notice and takedown remedies. Now, the new Copyright Act, Copyright Act of 2022 had made provisions that if someone uses your work on any platform, let's say, for example, your work is uploaded on, your work is sampled, right? And then the sampled version is uploaded on Spotify, Apple Music, Boomplay, or any other digital platform. You have the right now to send the message or a mail to that platform and say, this particular work sampled my work without my consent, thus an infringement on my rights. I want this work to be taken down. Now, the Copyright Act has created an obligation that lies on that platform to take down that work. So when you send that message, the platform has an obligation to make sure that first of all, they verify that what you are saying is right. And then if after that verification is valid, your claim is valid, they will refer that to the sampled version, that the owner of the sampled version. And if those people cannot provide any documentation that shows that they actually cleared with you or your approved representatives, then the platform has taken that song. Now, there's also another provision under, I think, section 56 that says that in the event that you possible, because obviously it's still possible that you lay a false claim on a song. Now, that's an offense. So if, for example, I have an issue with Ashake, and I don't like Ashake, so I want to like make him feel pain. And I send a notice to Apple Music and say, oh, Ashake sampled my song without my consent. Now, Ashake has the right, if after everything has been cleared, to take action against you for misrepresentation. So please, if you want to like exploit this particular new provision, make sure that whatever you are doing, you actually have that right to it. If you don't have a right to that particular song, please don't do it, because under this particular new act, the person will come for you. So this notice and takedown remedy is a new provision which has not been there before. But obviously, we have been taking down songs for a long while, but now there's now a copyright provisions that can help you to enforce your rights if at any point you believe that either the platform, right, is not doing the right thing, or the person that infringes your work is refusing to do the right thing. So you can be able to like leverage on these sections under the act, which is section 54 and 55 of the new act. Please, next slide. Now, the question becomes, what are the exemptions and what are the defenses? Now, as a lawyer or as someone in the music business, she understands the fact that every general rule has exemptions, right? Now, this is not different from corporated work. So for you to be able to use a corporate work, the first thing first is, if you want to use a work without clearance, without having to go through any stress, you need to find a work that is under public domain, right? So what is public domain? Public domain is basically a work that is within public access, right? Which basically means that there's no corporate protection for that work again. Now, to be able to like analyze public domain, you need to know what is the duration of a normal protection for corporate work. Now, for a musical work, which is obviously the composition part, it has a duration of the life of the author, right, and 70 years after that. Now, what that basically means is that if you're going to use a song under public domain, you need to first of all find out who owns that composition, right? The person that's dead or alive, right? And if the person is dead, how many years ago has the person gone? And they have to decide whether that works under public domain or not. For sound recording, is within 50 years from the first date of commercial release of that audio. So you have to also put that into perspective. Now, the second point is private use and non-commercial use. Now, you can also use a song if without requesting for any clearance, if you believe so much that whatever you're using that song for is not it's not for any commercial purpose. It's either for your own personal private use, or you're trying to like educate people on something. And you have to look at section 20 of the act. I think it went down to clarify what they mean by educational purposes, what they mean by non-commercial use. But when it comes to like private use, you should be very clear that the most important thing when it comes to private use is substantial use of that work, usage of that work, and that brings up what we call fair dealing factors. The court needs to clarify that what the use of that work does not in any way unfair to the user, to the owner of that right. So there are certain elements that the court will look at to determine these fair use factors, and they include one, the purpose and character. Like I said before, what's the purpose of the usage? Is it for commercial use, or you're just using it for a non-commercial? And if it's for non-commercial, I think the court will have to look at next, which is nature of the work, right? And then the amount used. So because you believe that your work is the sample is for a private use, or the sample is for an educational purpose, or the sample is non-commercial, does not mean that you go and sample all the songs, right? You have to like make sure that whatever you're sampling is also moderate, because the court will have to look at that too. And the market effect. So if the court believes also that your usage of that song is going to affect the owners of that work for making money from it, the court will not grant you that. So I believe that if you're going to make use of any of these defenses or exemptions, you should first of all try as much as possible to understand what the law provides for that particular usage you want to use that work for, and then also try to understand if you have been able to meet all the requirements under the fair dealing factor. Now, for public domain, I think that one's even more stressful because you have to first of all understand the fact that sampling is not just about, like I said before, sound recording alone. You have to clear with the holders of the sound recording and the holders of the publishing. Now, let's say, for example, the sound recording of that song is under public domain. Let's say, for example, the song is over 100 years since it was released. What about the musical work? And the fact that, let's say, for example, Ashake and Majestics are the holders of the publishing rights to this song. Let's say that you want to use song 100 years from now. Obviously, the sound recording should be on public domain, but the publishing might not be in public domain because obviously the writers of that songs or the composers of that songs might still be alive, or even if they're not alive again, possibly they might not be 70 years since they died. So public domain is always very, very stressful. However, there are some platforms that you go to that they are going to give you access to some public domain catalog. What that basically means is that these songs are songs that are already out of copyright protection, so you can use it without going for anyone for consent or approval. So the next slide. Now, I think what I want to make very clear here is people feel like you have to just clear with one music right holder before you use a song. Now, like I explained earlier on, sampling is not just about sound recording or about the song itself. You need to also clear with the holders of the composition. So, in as much as it's is possibly easier to find the holders of the sound recording rights, you have to do your due diligence to find who are the composers, who are the songwriters on this song. So it basically means that most times platforms would not tell you all the contributors to a song, right? But you need to do your due diligence and find out on your own. So for me personally, I believe that one of the key things towards doing this is that you have to start playing your song as fast as possible, as soon as possible, right? Which basically means that you cannot wait till when your song is about to drop before you start clearing it. It's very, very important that when you think you want to sample a song, that sample should be clear as soon as possible. Now, it's always difficult to clear a sample when the song has been released. One, because the owners of that sampled work think they have more bargaining power, have more leverage. So you ask for so many things that you might not even want to give to them, right? And if you're not careful, they might still sue you for copyright infringement. Secondly, if you're going to release a song, make sure that your split sheet is properly cleared and executed. What do I mean by that? The split sheet is a document that shows the contributors to a song, right? And what their entitled percentages are on that song. Now, if you are a composer, if you're a songwriter, or if you're an owner of a song, let's say, for example, you're having a record label and you use a sampled work, you must try as much as possible to first clear the sampled work, clear those that owns right that sampled work before you start talking about those that worked on the sampled version. Because if you don't clear with those that own the sampled work, you won't even know what percentage is remaining for you to share amongst those that worked on the sampled version. Let me go back to my example. I sampled Ashake's song, all right? Why BNL might ask me for different terms of engagement to clear their sound recording? Ashake's team might also ask me for different terms of engagement to clear their publishing. Likewise, Majestics, right? So before I even start talking about the producers that I worked with on this sampled version, I have to first of all clear with sound recording, which is why BNL in this contest, and then also clear with the people that control the publishing for Ashake and Majestics. If I don't do that, and I don't know how much percentage is remaining, I cannot go ahead and start having conversations about the new record. Now, most times this sample melody are usually added by, let's say, the producers. If your record label dealing with the producer that sampled the song, you have to make sure that in the producer agreement that you are giving to this producer, he needs to clear that sample or notify you that he has used a sample in that song. Because if you don't clear it, or you don't, if it does not notify you of that, ignorance cannot be an excuse on this contest. The owners of that work can still sue you for that. So if you know that you're a sound recording holder of the new version, or your record label wants to use a song, a producer agreement must clearly state that if that producer uses a sample to make that beat or to record that song without your knowledge, that producer must try as much as possible to either clear that sample or notify you of that usage so that your team can reach out to the owners of the sampled works right to clear it. The next point is conduct due diligence. Like I said before, you must as much as possible try to ensure that before you release a song, you have cleared everyone, you have cleared the record of everyone that will be on that song. And this is not about you doing this when you're about to release a song. You have to do it at least some few months if you have a sampled song, right, before the release, because there's going to be a back and forth. There's going to be conversations, negotiations that you have to deal with that might not you might not have plans before then, right? So that's very, very important. Now, like I said before, sampling without clearance exposes you to both civil and criminal liability. Like I explained in that section 54 and 55 of the Act. If you don't have any sample, you don't have any right to the song. The owner of the song can sue you for copyright infringement, right? And the copyright commission can also take it up on the criminal liability matter with you. So it's very important that you first of all understand what is being used. Is it a sample or an interpolation? Because if it's a sample, then you have a lot of work in your hand. But if it's an interpolation, then that gives you the direction to who you have to reach out to clear that composition from, right? And I would end this particular slide by saying that right management is an asset. It's just like it's more like an intangible asset, yes, but it's like, just like you owning a land, right? If you don't give anybody consent to go into your land, right, or to use your property, that cannot happen. Same thing with music. So I want to be very clear that right now in this our dispensation, musical rights, right, is very, very important now. And it's very important because most record labels, most holders of this right have understood the fact that the IP asset is as valuable as any other thing. So if you want to use it, you must try as much as possible to clear it. And for you as the owner of a record label, or as a manager, or even as a lawyer, you must try as much as possible to ensure that when you are trying to play a song for your clients, you put all these things into perspective. You put into perspective the fact that you have to listen to that song, right? And you have to ask questions. That's basically due diligence. Your clients might not understand all these things, but it's your responsibility, it's your obligation as a lawyer to ask for the file, listen to the song, ask questions, call the producer, ask him, did you use any sample on this song? Was there any composition that you used on this? So that you know that whenever your song is released, nobody will come for you, right? So I believe that if this 5 points are actually taken very seriously in the industry, we have an issue with copyright infringement when it comes to sampling. Please, next slide. Yeah. So I think I will end this by saying that sampling is not illegal, right? What is illegal is your ability not to have cleared the song before releasing it, right? And you need to ensure also that you don't use a song that you know very well that you may not have the resources to clear that sample. For example, just like you trying to use a sample as called Ashake, right? Now, for you to be able to clear a song that has Ashake on it, you need to ensure that you have money, because they're going to ask you to pay for it, or if you can't pay for it, they'll ask you for a very lofty percentage of the composition of the master's royalties that's going to come for that song. So try as much as possible to ensure that whatever song you are trying to sample, that one is a song they can play, right? And it's a song that you are willing to go home with whatever terms of engagement that they give to you, right? And then structure is also very important, because if you have a good structure, there's no way that a song will be released that you claim the sample. That's why I always advise creatives or record label owners, try as much as possible to engage the services of entertainment lawyers, right? Because entertainment lawyers will help you understand when to use a song and when not to use that song. So then last slide. Now, so basically, this is the end of my own presentation, I try to make as much as possible to like do within 30 minutes so I can take some questions because I believe that there are a lot of questions to be answered. So the idea is to be able to like answer more questions than obviously talk. I like asking questions, so let's see how that goes. Yeah. So the last slide here is about my company. I run a company called Optic Music, and this is basically part of our services, which is to help creatives collect their royalties, help them clear their rights, help them make sure that they don't infringe on anybody's sample, anybody's composition, right, or sample a song without clearance. So we try as much as possible to educate creatives through our community, and then we also try as much as possible to help them maximize the value of their compositions. I don't know if I was clear enough, but yeah, thank you for having me. But then let's have some questions.
Yes, thank you very much, Mr. Obina. You were more than clear, and you even from your presentation itself, it shows that there's a lot of due diligence to be done. Going
Definitely.
from the split sheet itself, looking at people that have the sound, the producers. There's a whole lot of things to unpack over there. And I just want to, before we move into some, because we have some questions, you made mention of that most of the time the sampling does occur through the producer. The producer introduces that sampling into it, and that you need to ensure that your producer has gotten the requisites, permissions and the likes. So I'm just thinking on an offhand, would having an indemnity clause with your own producer, would how to what extent does it shield you? In terms of when the owners of those copyrights or the owner of those rights do come for you.
Yes, I think that's a very vital clause to add too. Like I said before, whatever clause you feel can help you out, please do. All right, because at the point somebody must bear the blame for that negligence. So it's very important that if you can add an indemnity clause, why not add it? Let the producer indemnify you in the event of any party action, right, for that copyrighted work. But then it's also very important that you make it clear that he needs to disclose it, because let's make it this way. It's not just about the sampled work. It's about the fact that you yourself have invested money in a song, right? You have possibly gone ahead to provide marketing budget for that song. Now, when a sample is used without clearance, what that basically means is that that song cannot earn money for you. Like I said earlier on, the owner of that work can actually take you to court and request that all the profit you have made from that song should be accounted to him or her. So I think at every point, apart from the indemnity clause, there should be full disclosure, right? That this song we're about to release, I use a sample to produce it. I think that basically makes sense too.
Okay, thank you very much for the answer. So, when you were speaking with respect to, getting permissions, and how the court determines, the commercial value of it and the likes. Someone dropped a question, which is, and reference was made to the fact that are there any realistic Nigerian statutory exceptions that might protect unlicensed sampling in practice for example, parody or criticism? Or do you always require permission from the original owners? And the person gave a context and said, and there's a reference to a United States of American case, which is the case of the Two Lives Crew parody of Roy Orbison's Oh Pretty Woman in the case of Campbell versus Akuf Rose Music. And in that case itself, basically what the people did was that they made a parody version of the song to sort of, criticize the song itself, try to make a mockery of it. And the Supreme Court held in that case that the verse that it wasn't, they had not breached anything because what they had done basically was to critique the song via a parody. So even though that they were earning commercial value for it, it didn't in any way take away the commercial value of that original song that they made a parody of. So the person is asking that with respect using that in the Nigerian context, like on our laws, is there a scheme like that, or you always require permission across all boards?
No, no, like I explained earlier on, there's what we call the defense to copyright infringement, and that basically is one of them is fair usage, right? Non-commercial use of the song. Like I said before, like he must be able to defend the fact that the song was not commercially exploited. That was a very important one, right? And then it was for private use. Now, when it comes to fair usage that I was explaining earlier on, there are elements that needs to be proven in court. One of them being the market use of that song. How did it affect the rights holders? Now, if the court feels like your parody or your content did not in any way infringe on their rights to make money from their song, it's good to go. And like I said before, like what the case you mentioned now is obviously in clear conformity with the Copyright Act. So yes, in as much as I would say yes, I also believe that you need to make sure that you don't overuse that song, if that makes sense. You cannot have a song of 3 minutes and then you're using the whole 3 minutes to like that does not make sense, right? So
True.
that will also be moderated. The elements of fair usage is very important that you understand them because the fact that you use a song for a non-commercial purpose does not in any way mean that you are exonerated from copyright infringement. The element that has to be proven, and then that element is very important that before you use that song, you show that I'm safe to be able to like explore this composition or sound recording.
Okay. Thank you. So while we have some people sending us questions, privately, if you have any question to ask, you could please also raise your hands on the through the session through the Zoom platform. Okay, so we have a question from Thelma. This was posted publicly. So it says, how do courts determine substantial similarity in sampling disputes, especially in rhythm-driven genres?
That's why I feel, for example, like when it comes to substantial similarity, court have to look at obviously they have to call what call a musicologist, right, to the court. Now their work is to be able to like compare the both songs, right? If I claim that your song infringed on my song, and I'm saying that, oh look, I did not do that. This song is my own song. I did not in any way infringe on yours, but it sounds similar. The court will have to clarify what that similarity looks like. If it's substantial enough to be called the copyright infringement. And most times, what the court basically do is they call a musicologist, right? And and that's like an expert in the music compositions to like listen to it and determine whether that is substantial or not. But like it's actually very subjective. Like it's not something that you can just say this is going to be it or not. I think it's subjective to the court itself, right? And the judge that's obviously presenting over that particular matter. But then the most important thing is that if you have a copyright suit against you, and then the main aim of that suit is on the point of substantial similarity, please try as much as possible to get a music expert that you bring to court to like clarify that it's not. I mean, before you get to court, try as much as possible to get a music expert to help you analyze the composition and to be sure that you did not in any way infringe on this right. And also make sure that there's no way that you would have gotten to have known that there's an existing work with similar composition or sound recording, right? Because if, for example, the court finds out that there was a way that you have gotten access to that original work before now, you cannot lay claim to fair usage in that kind of situation.
True, true. Thank you. So the next question that I will have asked before the public one, uh, I had a reference to, calling a musicologist. So, but I'll still read the question. It says, from your experience, when a melody or beat is disputed, how useful is a musicologist expert analysis in Nigerian matters, and what should a lawyer brief such an expert to focus on?
It's just like you asking what can you brief a doctor to focus on? They would know their work, right? They know their work. So basically, I think it's very important when it comes to like the issue of copyright infringement, especially when it comes to like substantial similarity, right? And you need to prove that in court. However, what I also say is this: music experts are always very needed in court when it comes to things like this, right? You need to bring yours because the other party will have to bring theirs too. You understand what I'm saying? So you have to come prepared. in that kind of contest. But then yes, it's always been there. I think this particular case he had, I think last year or last year, and the whole idea was on his song, his generation song album he put out. Somebody was claiming that his composition was infringed on that, and they had to go to court in that contest, and they had to bring the musicologist to come and analyze the composition. So I think even if you don't bring it, if you don't bring a music expert, right, the court on its own would invite one to come. So, but it's very important that you have one on your own side if someone's taking you to court, because you need to be prepared as much as possible to be able to like protect your own rights, if that makes sense. But so yes, I'll say it's very, very important. If you have a case that has to do with copyright infringement, and then the main element of that case is on substantial similarity, then please get yourself a music expert.
Okay, thank you. So the next question is, it says, when advising a rights holder, how do you assess and articulate harm in sampling cases beyond just streaming numbers so that a court or the other side takes the claim seriously?
Okay, can you come again? I didn't get that.
So basically what the question is asking is that apart from the streaming numbers, that how do you assess the harm that a person whose work has been sampled, how does he assess the damages aside from the streaming numbers, and how do you present it to the court or to the other person that has infringed upon that right, so that they take you seriously, that what it is that you're doing?
Yeah, so first thing first is if you discover that your work has been sampled without your consent, right? The first thing first is to activate I think section 54 of the Act that talks about takedown. You request, you first of all send a mail to the infringing parties if you have their contact detail. If you don't, you request the platform to take down that song, right? And when the song is taken down, you can now sue for copyright infringement. Now, you don't have to determine the numbers that song has made. You just have to come to court and prove that this particular person infringed on my rights, and I'm here to request for damages. Now, when you request for damages, it's a whole complex world, right? You have to determine how much damage the court feels like you're entitled to and how they're willing to measure it. So it's not on you to decide what compensation the court will give to you. You just have to come to court with full arm, can ask for damages, injunction, and even request for profits accounts. And whichever one the court sees, they can work on it. But the most important thing is that if your work is infringed upon, I don't think you should be thinking about the numbers. I think that you should focus first of all on trying to protect your rights. And the best way is first of all to take on that song on all platforms, right? And then sue such person for copyright infringement.
Okay, thank you. So, earlier you noted that the instance of the YBNL and the Empire using the Ashake example. So, I was wondering, what documents and who do you reach out to, specifically what documents do you request from people whose songs or, sounds you want to sample to be able to ensure, what documents would you reach out to so that to be able to ensure that whatever agreements you are entering into or whatever verbal or implied agreements you have, you've covered all your bases with obtaining the necessary agreement for you to be able to use that sampling on your own work itself?
Yeah, so people call it different names, give it different titles. Can be called sample clearance agreement, can be called music rights clearance agreement, can call it anything. I think in Nigeria we have an issue with giving titles to things. I feel like this is a particular thing. I feel like the most important thing to know is that you have to clear your rights. Whatever you want to call that document is on you, right? But you have to clear the rights that you want to use. So the general context is sample clearance. You can call it sample clearance agreement. You can call it a music clearance agreement if it's an interpolation, right? But then the most important thing is whatever title you are given to it, that the basic terms of engagement that should be in that agreement is in that agreement. And one of the most important thing is what is the compensation structure for the usage of that work. So you have to clarify with the owner of that work, what am I giving you as compensation, as an economic benefit? What am I giving you as a moral benefit? So for moral benefit, one thing I want to add again is that moral benefits also gives you the right, to claim that a song that sampled your work that not give you due credit infringe on your work. So let's say, for example, I sampled Ashake's work,
Mhm.
and in my own song, when it comes to the credits, I did not credit Ashake as part of the contributor to that work. Ashake has every right to come and request for that to be done. If I don't do it, Ashake and his team has every right to sue for copyright infringement. And that's what Section 41 is talking about. And also, if I'm a producer of a work and I produce a work for you, and then the song is released, but you did not in any way give me my credits, I can also sue you for copyright infringement on that basis too, right? So the most important thing when it comes to a sample clearance agreement or a music clearance agreement is not the title. It's just the terms of what matters is the terms of engagement. It may not even have a title, but they have the terms that is signed. That's good to go. The code doesn't care about title. The code cares about what are the terms of engagement they are given. Even if I write it on my paper, I just put the name, competition, split. It's a document. I think as legal practitioners, we need to understand the fact that there's nothing like this thing about templates needs to stop. Like, if you understand what you need to do, right, then as a lawyer, you should be able to draft an agreement that can help like protect your client's rights.
Okay. You made mention of something with respect to, ensuring that even though the documents may have different names, ensure that uh the compensation clause itself and then the rights there. So I'm wondering, because you also mentioned moral rights, where you have negotiated with the person who has the intellectual property rights, is there also a need for you to negotiate with the person that owns the moral rights?
So most times, in fact, 99% of the time, whoever owns the rights to the song also owns the moral rights. So like I said before, moral rights cannot be assigned. Moral right can only be waived. Like I said, the moral right can only be waived. It cannot be assigned. So if using my context of Ashake, when it comes to sound recording rights, the moral right there belongs to YBN Empire. When it comes to publishing, the moral right there belongs to both the songwriter and the producer. Now, you don't need to go to meet somebody else to clear these rights. The moment you're clearing the economic rights, economic benefits, you clear for the moral benefits too. And that's what I'm talking about compensation, right? The compensation clause of that sample clearance agreement to clearly state that this is what I'm giving you as economic benefit for the use of your work. This is what I'm giving you as moral benefit for use of your work, which basically means I'm possibly giving you X amount or X percentage in the work, and I'm giving you credit on all platforms. Giving credits on all platforms is enough moral rights protection. And also the fact that when a third party wants to use that work, you have to also ensure that the agreement you're giving to this sample clearance and the sample owner is to ensure that it does not in any way interfere with your right to exploit that work going forward, right? So what that basically means is that if someone is coming to use your work for, let's say, maybe say for example, Netflix has licensed the use of your work for one of their movies, right? And then, for example, the episode they have to do with someone drinking alcohol, and then Ashake, being a Muslim, I say, you know what? I don't think I want this my composition to be on this episode or this particular timing. Now, this is a problem that needs to be cleared on the point of clearing that sample. So you need to waive their moral rights on that point of clearance. So waiver of moral rights means I have waived your right to tell me not to use your song on this or on that because it's against your belief or it infringes your reputation or infringes your this. So far as I'm giving you economic benefit for the use of that composition, your moral right is hereby waived. Now, moral right waiver is not something you assume. It's something that you put in the agreement that says this person hereby waives his moral rights on this composition. That way, nobody can come and stress you tomorrow, except the fact that, oh, what is due the person when it comes to money? You're giving the person the money, right? They cannot come and claim tomorrow, oh, why did you license this work for use on this platform? Then feel like this is an estate movie. Why would you do that? No, because you yourself, as an investor, as a businessman, you need to make money, right? So you need to try as much as possible to limit or remove any bit of hindrance to your right to exploit that new composition.
Thank you very much, Mr. Obi now. So we have another question on the chat box, which is from Telma. She asks, as a talent manager, I have to ask, does the current copyright framework fairly reflect how music is created today?
Yeah, it does. It does. I'll basically say that the new corporate art has been able to provide, especially when it comes to like digital platforms and third-party licensing in digital platforms. The new corporate art has been able to provide for different certain things that are not provided for the last art. For example, we have I think section 16, right? That talks. There's a particular section that talks about broadcasting organizations paying for the license of use of the musical works on platforms. And that was something that was not been there before, right? And then also the corporate acts has now provided for public performance payments. So number rights, right? Number rights payment that was not there before. But now if you're a performer, you are entitled to being paid for your number right. And these are things that are not the old art. So I'll say yes. When it comes to like licensing of musical works on digital platforms, the corporate art has been very comprehensive on that. It has made provisions for owners of broadcasting companies, which includes both your TV, right, your cable stations, your digital platforms like Apple Music, to be able to pay for the use of the musical works, which was not clearly stated in the last act. So yes, I'll say yes, sure.
Okay, thank you very much. So, we have another question too, which is on is there like a measurable test, that the court uses in determining whether, whether the hook or a part that you've sampled from a song, a phrase amounts to a substantial part of the work that has, infringed, that is being sued for infringing someone's, copyright.
I think possibly I'll bring our education partner next time I have this kind of conversation, right? But and what I'll basically say is that it's very subjective to the court, right? The court determines how they want to move on it. That's why I said earlier on that you must come prepared. You must try as much as possible to prove your own, right? And then let the court decide how they want to go about it. So the court might decide to like determine it based on the facts before it, or might call an expert to like help them analyze it, right? So either way, your own work is to focus on ensuring that you are not wrong, but you are right. If you are wrong, please don't go to court. I won't even say that now. If you believe that you are not sure if you have infringed on this right or not, and then you bring an independent lawyer, and then lawyer is telling you that I'm not also sure, or you bring a music expert who is telling you no, please don't go to court, because going to court is basically going to cause more problem. Try as much as possible to settle the matter before going to court. But yeah, back to what you said, I think it's very subjective. The use of determining whether a particular work sampled another work, or whether is the element of similarity is going to be proven depends on the is depends on the court. The court have to tell me whether they want to go ahead with that or not. But then it's very subjective.
Okay, okay. So, there's this recent case, I think it happened this week. Was it this week or last week, where, beautiful Nubia called out what's his name, Aifele, and he also called out Aifele and one other artist, BBO, saying that, that gospel artists continuously, infringe upon this copyright work. And I think he referenced Aifele's track, 2012 track, My Faith in God, where Beautiful Nubia's 1997 folk song, Seven Lives was copied. And also in this year, that which led to the renewed call out again from Beautiful Nubia, the BBO song, I mean, that, they copied it there. So, but I'm not wondering, is there, how someone, we can't say someone has a right to let's say tradition or culture, a cultural thing that I don't want to use, let's say folklore, but a thing that is related to a particular culture. So now say because you used it to sing first, that you own that thing. So is there a way where Araifele, could argue that, look, this is a cultural thing. You can't be saying you have the copyright to because you had used it at one point in time in your own song.
Yeah, yeah, true. Because if I want to reference the case I talked about earlier on, I think in that particular case won it, not because of anything else, but the fact that the court assumed that the composition that was in question was, um, was not primarily to the plaintiff, right? But then that be used as part of the culture in that part of the country. So I think the most important thing for us is to be able to like make sure you have a case. I don't understand this thing about people going to social media to start talking about copyright infringement things. I feel like if you believe so much that someone infringed your copyright, why not go to court and test the law? Uh, well, the law is there to be tested, right? So that
Yes.
tomorrow, if someone else has the same question, I don't have to go and start asking anyone. I have to go to case laws and know what the case laws precedents about that. So I think the most first thing first I would say is this: it's very dicey. It's very dicey, and this is where we do the music expert because the court alone cannot decide on this, right? The court alone cannot decide on this. We need to have a music expert determine if that composition or that sound recording is meets the criteria to be called a folklore, right, or a culture composition, because it's a very tiny line between that and you just using someone's work without consent. So it's very important that that can be addressed, which I believe so much that if they go to court, they can be able to like address that problem. But my own knowledge, what I would say is this: the Copyright Act has made clear provisions for when it comes to folklore and when it comes to like licensing of folklore, right? However, there are always going to be exemptions to the use of these particular compositions or things that deemed folklore, right? In everything you are saying, the most important thing is, did you infringe on a copyright, right? So if you believe that, I feel like sometimes we just have to understand the fact that we know these things then. We just sometimes don't want to listen to the voice in our head. I feel like you know when you are wrong about something, right? But even if you don't know when you're wrong about something, you have experts that will help you determine it. So I think our advice is to go to court. I want to see how that ends anyway, because that will help us test that
The
session of
waters.
yes, test the waters, yes.
Okay, I think I also agree with you because as you're speaking with you saying, let them test waters in court. I just remembered this man, I don't know his name, but it's the one that sang "Give Me My Lover." And
Okay.
where he was calling out Olamide recently, it was like last year, that he spoke with Alhaji Pasuma Honda, who he said had spoken to Olamide when Olamide released that song, Yemi My Lover, saying that his use of that word, Yemi My Lover, you know, infringed upon his own rights from the movie he did. So, but, I was wondering on the personal note that I don't think the use of the word itself, Yemi My Lover, is in any way infringes on any rights because looking at the song, I can't hear any sound apart from the fact that the use of that word, Yemi My Lover, was merely referencing what that Yemi My Lover did in that movie that you love to the extreme. That I'm not a lover to the extreme. So that's just my own personal opinion. I was also wondering, if it aligns borderline on what you also think, or you have a different disposition to it.
I cannot, I cannot talk about this matter because Olamide Wabede is our client, so cannot talk about it. But then, back to
Yeah.
what I was saying, right? If anyone feels like their right has been infringed upon, and then there's any complexities when it comes to the copyright acts about that particular composition, I think she go to court and test it out, right? I know that people will say that going to court is very, very stressful, but like at this like federal high court, right? I don't think we can move ahead if acts are not like laws are not tested, right? Because the laws are just there crafted by lawmen that may not be lawyers, right? But if you test the waters, can understand if you're right as a infringed or not. But for this contest, I cannot say anything about it.
Okay, thank you. Thank you about that. So we have a question from Elizabeth. She said, please, I didn't get the part of adding percentage in the split sheet for a sample for the original owner of the musical composition. Is it necessary?
So, like I said before, every work has benefits. We have economic benefits, we have moral benefits. If you want to sample someone's work, you must be able to compensate them for the use of their work. Now, you can compensate them by paying them a fee, a sample fee, right? Or you give them royalties on the song. Sometimes you can even both of them. Some people demand both payments and royalties. So you need to decide what you are willing to give away. And then it's not, first of all, I want you to understand the fact that when it comes to sampling, the right is not on you. No matter what you think, no matter what you think you want to do, if the owner of that work says, I want you to give me XYZ, if you can't find a way to make them compromise and then possibly say, you know what, I can take X, you can't use that work. That's why it's always very important that you try to clear the work before you release a song. Most times, all this idea of, oh, I can only give you X, I can't give you Y, and the person that owns the song is telling you they want X and Y, comes up because you have already released the song and now you have given people out, you have given out splits on the song, and you not put in consideration the fact that there is a sample on that song. So I think the first thing I would advise is, if you're going to declare a song, know that the owner of that sampled work has every right to claim anything he wants to claim on that song. It's either you accept or not, right? It's not a matter of you must do this because I want it. No. If you cannot clear the song, please don't use that work.
Thank you very much. Thank you very much. So we have another question which says, what contract clauses and internal clearance processes would you recommend every serious label or artist to adopt to minimize feature sampling disputes, especially from producers and featured artists?
I think I'll tell them to come with us as personal LP. We'll help them out on that. But then, so I'll say something with structure, right? You need to treat music as business, first of all, right? So if you're doing a business, there are documents you sign. You don't just go and start working with somebody based on oral agreements. You must take down things. In fact, the corporate act provides that if I'm going to enter into any transaction with you that would require me to give you my rights exclusively for a period of time, right? That kind of agreement must be in writing. So what that basically means is that if I'm going to exclusively give you my rights or grant you the right to use my work exclusively for a period of time, that agreement must be in writing. So it's very important that whatever you are doing in the industry, try as much as possible to ensure that you not only protect your music rights, but protect the right of other people that you are going to use their works on your own sound recording as a record label. So that means, first of all, you need to get an entertainment lawyer that is going to work with your record label. And the entertainment lawyer must be able to be one that have experience handling music rights. Because if you don't have an experience in the industry, you cannot differentiate between sampling and interpolation. And you cannot even decide which one is which at that point. Right. So an experienced lawyer understands this system. An experienced lawyer knows what to do in that kind of context. So as a record label that's willing to invest money to push a record or to push an artist, I don't think it's difficult for you to get the right team to work with you. So the first thing I would say is structure, the right structure, which includes getting the right people that have experience clearing music rights to work with you to ensure that you don't infringe on anybody's music rights. Secondly, there needs to be a kind of clarity in regards to what you want to do with every song you're trying to push out. You need to know if you are willing to put in X amount towards clearing that sample or not. A sample is not a do or die affair. If you feel like this sample is proving difficult to clear, please leave it. Right? Please leave it. Before a sample is even used in a song, you must try as much as possible to reach out to owners of that work to know if they will agree to work with you on that sample. Even if they don't give you any written agreement at that point of clear of production, try as much as possible to at least reach a terms of agreement with them when it comes to compensation. Okay, I want to use your sample on this my song. What can I give you as compensation? How much would you ask from me? Let's agree on this, agree on that. Even on the point of producing that song, you need to know what you're dealing with if you want to go ahead with that sample. All right. So I think for me, the most important thing is structure and getting the right team to work with you. Anybody can open a record label, right? But what that is, if that record label will go far, is the team that record label has built around it, if that makes sense.
Yes, it does. Yes, it does. Thank you very much. So we have a question. It says, From an evidential standpoint, what would you advise people to start preserving now? Is it project files, drafts, emails, posts, so that they are well positioned to be able to prove or defend a sampling claim that comes up later in life? So what do you advise they start documenting down or preserving?
So documents are very important. The file is also very important. But the most important thing is, did you sample that song? Like, if you sample the song, if you like, have all these documents. If there's no sample clearance document to show, you're in trouble, right? Because a song that is sampled is very clear. You hear it when you listen to it, right? And even if you claim that, oh, I didn't hear this song before doing it, don't think the fact that it sounds the same as this other song. You get me? We had a recent case whereby a client of ours sampled the song, and we tried to reach out to the owners of the song to play the song, and they were proven difficult to play that song. So what we basically did was that we had to now use the interpolation. So instead of using the whole sample, which requires to collect with the sound recording and composition, we just used the lyrics, which helped us to clear with just the owner of that composition. I think that makes sense. So most times, if you're using a sample and then the person is proven difficult to clear that sample, ask yourself a question: do I really need the sound recording, or is it just a particular thing that I need for that song? Maybe the beat, maybe the lyrics. Do I need to clear with everybody? Do I need it to be a sample? Because sampling is very stressful to clear. It's easier for you to clear an interpolation and declare a sample. So the first thing first is to understand, I've reached out to these guys. I want to use this sample. They're proving difficult. Do I need them? Can I use this song without clearing with them? If it's possible, for example, let's say for example, I want to clear this door by Ashake, and then I reach out to the owners of the sound recording, and why Beno is saying no, they cannot agree to my terms of engagement. This is what they want, and maybe what they want is not what I can give to them. I'll ask myself a question: do I need that sound recording, or is it just the melody that I need? That's to say, is it just the beat that I like, or is it what he said in the song that I like? Then, if it's something that you can distinguish the composition from the full music right, then if it's just the composition you need, you can reach out to Ashake directly and say, oh, I want to play your line that I want to use on my song, or it's a beat on this song. I like it. I want to sample it. That's for Magic Sticks, and clear with them. So there are different things that can be done in that context. However, the most important thing is you need to get a team that is experienced, because most times the difference between a sample being cleared or not is just relationship, right? If your team has a close relationship with the other team, it works, right? Or if your team knows how to handle this kind of conversation, it works. It's not a matter of, I want to use your song and I have 10 million to pay you. You must take 10 million. It's not a must. The person can say, I don't want 10 million, I want 20 million. And if you cannot agree on terms, you can use that song. As simple as that. And it's very important that we know this, because at this our dispensation, sample songs is the next way going, because I think at this point we need to start sampling most of our old catalogs. That's the only way to bring in fresh ideas, right? And that's been happening for a long time. From Burna Boy to Rema, I think for the last 2 years, we have seen several sampled songs, several interpolations being used on new versions of the music. And then is the next way we're going to go. So it's very important that you understand sampling and interpolation and how to clear the rights.
Okay, thank you very much, Mr. Obina. Thank you. Thank you so much for the time, and thank you so much for our attendees.
Thank you.
We don't have, I think we've asked the last question. I don't know if anyone also has another question to ask. I don't think there are any new questions in the chat box or in our private chat. So I think what's left for me to say is thank you so much for creating the time, to be here with us. And
Thank you.
and I'm optimistic that as much as I have also deepened my knowledge with respect to music sampling and also the intricacies of the music business itself, I'm optimistic that people who have attended also to, have also been exposed to that bliss also to, tap in from your fountain of knowledge. So thank you so much. Thanks so much for our
Thank you
attendees.
very much.
Thanks so much. So we'll be sending the recorded version which is when it's published on YouTube, to our attendees, and also our next KSS for the month of March will also be information will also be passed along. So thank you so much, everyone. Thank you for your time. Thank you. Bye.